case of State v. Castillo, our third case today. Justice Nielsen is recused, and we are pleased to be joined by Judge Niner. A couple of quick thoughts before we begin. We've allocated 20 minutes to a side, but you'll likely exceed that because we have lots of questions. And we'll continue to ask questions as long as we think it would be helpful to our understanding of the case. So if your time runs out and we're still asking questions, you need not ask permission to continue. That may mean that by the end of the argument, one of you will have had more time than the other. Not a reflection of how we view your case, but rather of how many questions we had with respect to your issues. So with that preface, let me ask counsel to enter your appearances.
Andrea Garland on behalf of Mr. Salvador Castillo.
Welcome, Ms. Garland.
Good morning. Michael Palumbo for the state of Utah.
Good to have you with us, counsel. Okay, Ms. Garland, let's begin.
May it please the court, counsel, Andrea Garland on behalf of Mr. Castillo. We'd like to begin with the opinion testimony, then get to the victim impact testimony issue and the rest as time permits. The problem here is that the opinion testimony was not based on reliable methods and it didn't apply to the case. Schumacher testified and the trial court found that his method was to draw his theories about sexually abused children from interviews of children who may or may not have been sexually abused. It is an unreliable method. It has an analytical gap where it requires faith that the interviews recounted accurate information, but the witness testified that not all the interviews were accurate, and he did not know which of the interviews were accurate and which were not.
Couldn't Mr. Schumacher, though, testify that in his experience of 900 interviews, that he observed that reporting was delayed? Whether or not there was truthful reporting or not, couldn't he testify that when children come in and testify about alleged abuse, that many of those times, I don't want to put words on it, but that he's observed that some children will be delayed in their reporting?
Well, I think that that's unreliable. The South Carolina Supreme Court in State v. Chavez said that even 5,000 interviews did not make it reliable for the interviewer to do more than talk about interviews.
But why couldn't he just report that that was his observation?
Because it doesn't, where science tests itself, these are unreliable observations unless they test themselves, and he does not.
What would have been tested in that case? What would he need to test in order to report that in his experience, when he hears about children alleging sexual abuse, that oftentimes what they're alleging occurred perhaps months, years, whatever before?
That would require some kind of follow-up to determine which interviews are actually based on accurate interviews, on accurate information, such as following up with determining which ones were corroborated by confessions or.
Well, if he was trying to say that in fact those were accurate reports, I think you'd be right. But I guess what I'm just trying to, maybe I'm not asking this correctly. If he's saying, I've done these interviews and I've observed that children, what they're reporting, even if it's alleged, I'm not saying it happened, but what they're reporting, oftentimes they report things that occurred many months or years prior.
I understand.
That's just something that he's just observing in the children that he's spoken with, that this is in fact what he sees just from his observation, regardless of whether these allegations end up being true.
I understand what you're saying, but where the trial court has a gatekeeping function to maintain reliable testimony getting to the jury, confessing up front the unreliable flaws of the testimony doesn't transform it into a reliable method. And so here, there's no follow-up, there's no investigation of alternative theories of reasons for delay or reasons for what the children are saying. There's no there's no validation. This is purely anecdotal testimony. It relies on the interviewer's ipsy-dixit. We can't expect that another interviewer is going to verify or replicate or validate the results, or at least that hasn't happened here, certainly. So we're arguing that this is an unreliable method in cases where they have talked about reasons for, say, counterintuitive behaviors. Those particular cases have drawn from the literature, such as in, say, Treminio or Abdur Razak. There's an extensive engagement with the peer-reviewed and scientific literature. For another example, in the Acker case, they considered multiple case studies, multiple longitudinal studies of children known to have been sexually abused. Here, on the other hand, we don't have any of that. The trial counsel was concerned that the witness had only looked at a survey article and said that some of what he saw was confirmed in the record, and we don't know, the record doesn't show which of his theories are reliably stemming from science.
What about, though, when counsel, in conversation with the court, said, I don't have concern about him testifying about generalities of that there are late reports and the reasons behind them. My concern is with quantifying those. And so what do we do with the fact that counsel basically told the court, I'm okay with a certain level of testimony, I just don't want the expert testifying about specific quantifications, that something's rare, something's common, those kind of things.
You know, he does say that, but then if you read his entire argument all the way to page 686, he says, I'm okay with this, but then he also argues why it is unreliable, unverifiable, unhelpful. He does say those things, as you've said, but then he goes on to explain why they are inadmissible.
Ms. Garland, maybe I could ask a follow-up related to what Justice Pullman's asking, and that is, when Mr. Schumacher testifies about delayed reporting, is he improperly bolstering for the credibility of the alleged victim in this case, or is he just identifying that that is a factor that he often sees?
Well, I think it is improperly bolstering because it's giving unfounded profile testimony. There's no validation of his method. He's saying this is what I see, but there's nothing to show that what he's seeing is reliable. And so the problem is twofold. He's relying on an unreliable method, and it's being used. Later, the state argues in closing that what might otherwise be problems with credibility are in fact seen in Schumacher's experience, but that is not a reliable method. It hasn't tested itself. It's purely anecdotal, and it relies on his ipsy-dixit.
Let me follow up on, please, Chief, please.
As to the reliability, his testimony is, in my experience, false reporting is rare. And I take it that's your chief complaint, the use of the word rare. Is he saying that, or is he saying false reporting is rare generally?
Well, he said false allegations were rare, and then he doubled down and said that more often they were false recantations, which was inflammatory.
Yeah, and my question, sorry, it kind of goes to is he referencing the kind of the universe of his own experience? Or is he making assertions about evidence more broadly?
The trial court found that he was drawing his observations from his personal experience. It's not clear from the particular statement what exactly he was referring to, but that particular statement was completely inadmissible. It indicated that the defense, which was that this was a rare allegation, it indicated that not only would that be rare, but it would be even rarer than rare, because more often these are false recantations. It indicated that the defense itself wasn't really seen in science, and so it was inflammatory, and it was both deficient and unreasonable and prejudicial for that to even come in. I know the state has argued, well, there was some kind of corroboration in the form of texts and some kind of family confrontation. That's not what this court has referred to as corroboration in the past. The reason that this court looks at, say, physical evidence or third-party testimony or a confession to strengthen a credibility case, because nobody has to weigh that particular testimony. Here, the evidence was conflicting as to what these texts had said. We don't have any texts in the record. The evidence conflicted as to whether any kind of confrontation even existed. And even after that, AV asked Castillo to be her godfather at her quinceanera. So even as
So I'm sorry, are you addressing prejudice now on
I am.
the IAC for
I am.
not asking for a mistrial or to strike that testimony?
I am, and I would add that the state doesn't dispute that mistrial would have been appropriate and probably granted in this particular case.
Well, I mean, in fairness, I didn't see much analysis about why a mistrial would have been appropriate. I noticed that you said the counsel should have asked for one, but I didn't see any analysis about why reasonable counsel would have requested it and why it's reasonably likely that the court would have granted it.
Well, because it implied that the science doubts the very defense. And for that reason alone, it's completely prejudicial. The trial court had previously ruled that it was substantially more prejudicial than probative, and had ordered it excluded.
I mean, I don't think there's any question that it was error, right? That it shouldn't have been said. I'm just not sure I saw an explanation from your briefing about why all reasonable counsel would have requested a mistrial. And while we should conclude it's reasonably likely one would have been granted.
I think all reasonable counsel would have asked for a mistrial here because it is so inflammatory. It casts the weight of science against the only defense here. And that is why it would have probably been, a mistrial probably would have been granted, because it is so inflammatory, it is so wrong. And
Why do you say that it puts the weight of science behind it? You keep talking about this as scientific principles, but wasn't he actually testifying from his experience and not based on any scientific or technical knowledge, but based on his experience?
My answer is twofold. He was testifying as a witness whose scientific or specialized knowledge may serve as the basis for expert testimony.
And we've said that the other specialized knowledge can be experience of like a law enforcement officer, right?
Well, there was never any explanation of why his specialized knowledge of interviews made him reliable. And I'm sorry, what was the rest of your question?
Let me put it this way, because I want to put aside him saying that it was rare, which was improper. The court ruled that it was before trial, and the only question there is ineffective assistance, right? I want to talk about the actual Rule 702 ruling. And I understand that you're arguing that this isn't even admissible under Rule 702 because it's not being applied to the facts, but Judge Nider referred to our bolstering cases. We have a long line of bolstering cases where we have said you can't actually opine as to whether the officer, for example, thinks this witness is lying or truthful. But you can bring on someone who talks about general behaviors of victims without applying it to this individual case. So haven't we, in our bolstering cases, sanctioned the exact thing that happened here?
No, I don't think so. The only relevance to that testimony and the only implication is that this witness is in a class of persons who don't make false allegations.
But what about those cases where we say there's a difference between saying, I believe this victim, or I think it's likely that this victim is telling the truth, and saying, here are some of the common patterns we see in child abuse victim reporting?
I don't believe a jury is going to make that fine distinction.
But we have, correct, in our case law?
I think that the Court of Appeals has made that distinction at times. I don't think it's a relevant one because what goes to the jury is a scientific opinion that these allegations are not apt to be false because it's rare that they would be false.
And I'd push back on that scientific opinion. I mean, this witness never claimed to have any scientific expertise, correct?
Well, no, he didn't, but psychology is a science according to this court, and he's theorizing about psychology. And he's basing his theories on his purely anecdotal, uninvestigated, incurious experience with interviewing children who may or may not have been sexually abused.
And could the defense have called a psychologist that could have presented a different side of this from a more scientific perspective?
I'm unaware of a case in which that has happened. I would say that in cases that have approved of scientific evidence, they've drawn the opinions from actual science. That's not what happened here. And for those reasons, this court has said that we don't look at whether the person was reliable, we look at whether the method is reliable. This is not a reliable method, and there is no explanation for why it would have been reliable.
How is this different than a police officer who testifies about what a user quantity of drugs is in his experience as a drug interdiction officer of 20 years? Or, how is this different than that?
Well, I think that that particular case, Prettyman, probably is unreliable for the same problems here. It is an unreliable method. On the other hand, in those cases where perhaps it is specialized enough, such as all of the drug dealers on this corner do this, when it's simply cops talking about cop stuff, that may be reliable, although even in those situations, there is no follow-up if there is no follow-up to see what what observations are actually corroborated by some kind of conviction and a rate of error derived. I mean, that could easily be done. When it's not, I think that detracts from the reliability. And to say, well, it's just experience, I think that similarly abdicates the trial court's gatekeeping role to ensure that the jury only hear reliable testimony.
Can I just go back to something I was asking earlier? So if all that Mr. Schumacher was testifying to was that in his experience, children who allege sexual abuse often report it in late fashion for these reasons that they've articulated, would he be qualified to do that, and would that be reliable?
No, I don't think that would be reliable at all. I mean, conceding the unreliability of his opinion straight up doesn't transport it into being reliable testimony.
But what about that wouldn't be reliable?
Well, because in order for that opinion to have any weight, it would have to be tested.
Tested against what? It's just his observations over 900 interviews that he's observed children who are alleging abuse to say certain things. So I guess I'm wondering, what would you come in and test about that to make it reliable?
What could make that reliable would be is if he were to do further investigation to find out which of those observations were correlated by convictions and to figure out if what he's seeing are maybe some strange one-offs, if it's something particular to a specific culture.
But maybe, wouldn't that be only true if he was trying to then opine that those children in fact suffered sexual abuse?
Well, no, because that's, he's giving information about a class of children that are sexually abused, but he's only basing it on children who are claiming sexually abuse. And you're saying, well, wouldn't it be okay if he were to just say, well, this is what I've seen? The problem with that is that his observations they're purely anecdotal, and the only weight that they can have is outside of a courtroom when he's doing interviews or he's training on how to maybe investigate after interviews. It doesn't have relevance or applicability in a courtroom where what the fact finder is trying to decide is whether a child has been sexually abused. It's not helpful information because it hasn't been validated, but it will be given weight as if it were validated, and that is our objection. If there's no further questions,
Thank you, Ms. Garland.
thank you.
Mr. Palumbo.
May it please the court, Michael Palumbo for the state. Castillo cannot show any reason that his conviction should be disturbed. First, the main topic that was discussed was expert opinion testimony, so I'll pick up there and focus there. Castillo abandoned his claim that the general testimony from the expert was inadmissible. He abandoned it by repeatedly saying that he thought it was okay for expert to testify about these general observations that the expert was qualified to make. He said that a number of times during oral argument, and though he may have said other things as well, he largely conceded that point, and this court could if you chose.
Then why do we have a ruling on it? Why did the court go forward and rule on the motion?
Well, there was still a pending motion filed, and so the ruling on whether to admit or deny or to exclude was still something the court had to resolve. But the specific points of whether the testimony should be admitted at all on those general points, Castillo said he was okay with all of that. So
okay, I'm just not clear on that because I mean it's not as if the court issued an order saying I am granting. Let's see, it was their motion. I'm denying the motion because the defendant has conceded that or the defendant didn't withdraw the motion. So I'm just a little confused about what the effect was.
So the defendant did not withdraw the motion. He scaled back what he was asking for in oral argument on the motion. He indicated that he didn't have a problem with the expert saying that delayed disclosures happen. He had a problem with the frequency evidence, and that's what the court, that's another issue that was addressed in the opinion.
Do you think that counsel also waived the challenge to 702, is it C3, the part about applying the facts to the opinion or the opinion to the facts? Do you think that was waived, or do you think that still was on the table?
I believe that was waived because by conceding that they were okay with the expert testifying about general principles like delayed disclosure, also conceded the reliability issue under 702C or 702B.
Do you think counsel also waived the question of whether it was helpful to the jury? Because at one point when he was talking about that he didn't have concerns about the general testimony, he said if it was helpful to the jury. So do you think that was still also part of a life challenge?
I do. I think what remained after oral argument was a challenge to frequency testimony. And the threshold question of helpfulness and reliability for the general testimony about whether delayed disclosure happens and the reasons for that, that was all waived.
Okay.
But even if this court chooses to address the claim on the merits, it fails because the district court did not abuse its discretion in allowing the expert testimony here. So as we've been discussing, 702 permits a witness who's qualified by knowledge, skill, experience, training, or education to testify to special knowledge that will help the trier of fact. And that's not limited to hard sciences. It's not limited to sciences that could be tested in a laboratory. There's many areas of expertise where that is not present. Car mechanics could testify as experts based on their experience as car mechanics. It does not require hard science or the trappings of a laboratory to make it admissible. And that's long been the case. That's discussed in the comments, the advisory comments to Rule 702, and all of that informs that 702 is not so limited as defense would have this court rule.
Do you think that the rule that 702B3 is ambiguous and that the comment helps clarify the ambiguity, or do you think the rule itself is clear?
The rule itself is clear. The comments are just helpful context. But the rule, as the state argues in the brief, could be is quite clear, and the testimony here was admissible under that.
I'm not sure if you're aware of this, but we have published for public comment an amendment to Rule 702 that actually clarifies this, or I shouldn't say clarifies. I'm characterizing it. Let me just say it changes the language of that third prong to say that it doesn't necessarily have to be applied to the facts of the case. And I'm just wondering whether that pending amendment helps you or hurts you. Does that suggest that the old rule did require it to be reliably applied to the facts of the case, or do you read that pending amendment to be a clarification? No,
the pending amendment doesn't change the analysis here. 702C is clear enough as is. The amendment will make what's already permissible under the rule even clearer, but I don't think it changes the analysis at all, especially when considered in light of the advisory comments.
Will you respond to counsel's argument? I think her primary argument about the expert is that he can't testify reliably about what child victims of sexual abuse would say or whether they would report in a delayed way, because he doesn't know if those children he actually interviewed are in fact victims of sexual abuse, unless he were to follow their stories and see if there were confessions or at least convictions, something to that nature.
That would be a valid argument if the expert was being asked to opine on the veracity of child victims, and he was not. What the expert was asked to opine on here or provide information about was trends that he observed or his professional experience of what happens when children who are alleging sexual abuse disclose that. And a similar issue came up in State v. Martin. There was a question about a very similarly qualified expert was testifying about child memory, and there's a challenge to the expert's qualification to do that. And this court said that simply describing the trends and tendencies that are readily observable from a forensic interviewer does not require additional qualifications in psychology or any other fields. The same is true here. These observations, and particularly because I think the most relevant testimony from the expert in this case was related to delayed disclosure. Those are things that, regardless of whether, every disclosure that this interviewer received was accurate or was later recanted, the interviewer is still able to say, of the nearly 1,000 interviews that I've done, children have told me how long it's been since the abuse occurred. That's just an observation, and the fact that he has had such extensive experience both conducting the interviews and observing the interviews means that he's qualified to make that observation. And that type of observation is helpful here because jurors may not know that. The fortunate people who don't have to spend a lot of time thinking about child sex abuse may not ever consider that children may delay disclosing or that victims may delay disclosing for a number of reasons. This type of testimony is extremely helpful to jurors who need that information so that they could perform their function of assessing the credibility of witnesses. I think this case is clearly distinguishable from many of the cases that defense cites, the improper bolstering cases. The expert here was a blind expert, so even if he wanted to, he couldn't opine on whether the victim in this case was telling the truth or not. And I think the clearest distillation of the expert's testimony and the purpose for it came up in the state's closing. This is how they used it in their rebuttal. The prosecutor said, sometimes children who have been abused have lots of reasons why they don't come forward. It doesn't mean that what they say is automatically false. It doesn't automatically mean it's true either. Look instead at the evidence. That's the purpose of this expert testimony. It's to give, just as the comments to Rule 702 say is permissible, it gives the jurors an important tool that they need to assess the other evidence and perform their function.
Mr. Palumbo, though, isn't it, I'm looking at the appendix D that has the transcript in it, and I think in terms of it being a factor, right, if he testified a lot of the children, or many of the children, if not all of the children that I interview, lack eye contact, right? He's describing something that is different, but he's giving reasons for why a child might delay disclosure. And all of the reasons, and I'm on page 164 of the transcript, says that there are a number of reasons for why children delay disclosure. For very young children, they may not understand what's occurred as abuse. They may not have a frame of reference for that. Then he goes on, for other children, it's some of the reasons why they may delay their disclosure may be fear of consequences if they report their abuse. So he's not just opining as to the fact that the delay occurs or that it exists in a lot of those cases, but why it occurs. What experience does he have if he hasn't followed these cases, if he doesn't have some statistics that he then can opine, which he's doing here, and explaining to the jury, look, this was a delayed report, right? I mean, let's be frank, nobody would be asking these questions if there wasn't a delayed report in this case. The delayed report in this case could be for these reasons. And isn't that then something that 702 should directly answer, is how does he know that?
He knows that from conducting interviews, because in addition to learning that children may, have waited from the time of the alleged abuse to talking to him, he's also going to know from the interview the reasons that they give for that. And
so you're telling me that these 900 children all say why they've delayed the reporting? I will be frank with you, that's not my experience.
I'm not sure that that's true, but I'm not sure that that's necessarily what the expert was saying, is that all of the children say the same thing. I think he was giving examples that, because during cross-examination, he also acknowledged that he doesn't know whether what children are telling him is true. It's not his job to follow up on that. His job is to gather evidence, and what happens, happens. He also, I believe, I'm trying to recall the beginning of his testimony when he's setting it up, but I don't think he claimed that every child he talked to disclosed abuse. I think some children disclose, other children don't disclose. And I'm not sure if it was specifically discussed. in any event, he never made reference to, trying to give statistical evidence for how many children, use one reason versus another. But even if that were the case, I don't view that as bolstering or improper in any way. He's just explaining to the jury, delays happen. Some reasons that I've heard about in my experience are X, Y, and Z, and then drawing no further conclusions about what that means for the facts of the case. According to his testimony, he didn't know any of the facts of the case. He was unfamiliar with what the specific allegations were here.
So, but then he takes it one step further in this next portion of the transcript where they're talking about the delayed reporting, and this is on page 165, line 17. Have you seen times where children have come forward with abuse and then later retracted what they said? And then it gets into what are some of the reasons a child might have retracted what they said, and this is the problematic, I think that everyone agrees. The answer is outside the 702 ruling. Some of the reasons may be because the abuse actually didn't happen, and they may have come in and made a false allegation, although that's rare. More oftentimes it would be because they had pressure from other people within the family or from other outside sources, or their own guilt or having disclosed something about that, and may feel like they had to take back what they said. Isn't this part and parcel of the problem, that then all of a sudden it's not just about delayed reporting, it's about whether or not these could be false allegations, and that is the point at which counsel may have or should have asked for a mistrial, because it's not just about the delay, which he had conceded may be appropriate, but then it evolves into this false allegations portion of it. How does that not violate the 702 ruling, and how is it not the basis for a mistrial, and how is it not ineffective assistance then that counsel didn't ask for a mistrial?
So, okay, it's not an effective assistance of counsel because trial counsel wanted the false reporting testimony. That's what trial counsel hit on in cross-examination and then followed and argued in closing, that he wanted the expert in this case and used it to his advantage.
But this was a question from the state, wasn't it?
It was. That question came from the state.
So the door is opened by the state.
Sure, but
Okay.
but the defense's theory of the case was that, and I'm going to use the victim's, the name that we assigned to her in the briefing, Celeste. The defense theory was that Celeste was making this up, that this was a false report. And so from defense counsel's perspective, it was helpful to have the state's expert acknowledge that false reports occur. Counsel did not want the frequency with which those occur to come in, and that was, the basis of the pretrial motion in limine on that. But putting that aside, a single reference to, whether it's rare or common or not, defense counsel could have reasonably still decided, I got what I need. I've got the fact that the expert is acknowledging false reports happen. Let me hit on that during closing argument. And defense counsel asked similar questions. During cross-examination, he got the expert to acknowledge that he has no idea whether the children he talks to are telling the truth. And then he confirmed again, false reporting happens, and there's a variety of reasons, known and unknown, that false reporting happens. And then during closing argument, made his full-throated argument based on all the defense evidence that, look, Celeste wanted a U visa, so she made this whole thing up, and referred to the fact that the state's expert acknowledged that false reporting happened. That's a strategy. I mean, that was the defense's strategy to use that. The fact that, along with all of that gold was a little bit of dirt from the frequency testimony, reasonable counsel could say, not a big deal. Like, we're not going to talk about the frequency here. So I think that's the response. We've kind of, transitioned to talking about this IAC claim. That is the state's response. In addition, a single reference to rare retraction testimony, or rare retractions, was not prejudicial. It wasn't emphasized by either party. defense immediately stepped in and said, we don't want to go further down that road, and stopped the flow of that kind of testimony. So there was no prejudice resulting from that either. If I could return for just a moment to talk a little more about the 702 issue generally. So I just want to briefly address the plain language of Rule 702 and why expert's testimony here was reliable. So the methods and principles that the expert relied on were reliable because expert testified that he trains others in the field of forensic interviewing. He did acknowledge that as part of his duties, he stays abreast of research and publications in the area of disclosures, and he also mentioned child development and other areas that he was familiar with. And his CV also indicated that he provides ongoing guidance. So he had more than sufficient background for the court to find that it was reliable under 702C as the type of thing that experts in the field commonly rely on. And defense argues that application is necessary in order to meet 702 requirements. State disagrees for the reasons explained in the brief, but just to get to the point, it's the comments and the advisory comments make it clear that sometimes the jury just needs to know things that are important to know to make their decision, and this is precisely that type of evidence. Many courts have recognized that. There's been a slew of Court of Appeals opinions in the past year and a half that analyze this type of testimony and find it admissible or find a lack of ineffective assistance for not objecting to it.
Can I ask you a question about that case law? Because my recollection is, as yours, that we have a lot of case law talking about that this kind of general evidence is admissible. Is that all Court of Appeals decisions? For instance, do we have a Utah Supreme Court decision saying that, for instance, in the bolstering context, saying that it would be appropriate if the expert was just giving general observations from their experience, they just can't apply it to this particular victim? Is that all Court of Appeals cases?
I believe State v. Martin comes, I think, the closest.
Okay.
And in that case, similar types of testimony were found to be admissible and appropriate under 702. I think another important theme that comes up in a lot of the recent cases is that, just because testimony gets into statistics doesn't make it necessarily de facto inadmissible. The problem is when you're trying to infer that someone is telling the truth or lying based only on anecdotal statistical evidence. That was the case in Eorg, where the witness actually testified about whether she believed the victim was being truthful. That was also the case in Burnett, where the expert was actually qualified and then testified about tools that the expert uses to assess truthfulness. That's not this case, obviously. The expert never got even close to that, and also never got close to statistical evidence. The closest that defense could point to is phrases like common or more often, and those are just colloquialisms that refer generally to things that happen with some frequency. There's no scientific gloss on that puts the jury at risk of basing its conclusion on the expert's assessment of truthfulness. Defense was asked about...
Unless there are further questions, looks like your time might be up.
Thank you, Your Honor. If there are no further questions, the state would ask you to affirm. Thank you.
Thank you, Mr. Polanco. Ms. Garland?
Thank you, Your Honor. To the degree that, that the state wishes to put on scientific or expert testimony about, say, delayed reports, they need to be able to take that from reliable science. That didn't happen here. The witness didn't explore alternative reasons for any of what he saw, such as that the abuse that's been claimed didn't happen. His reliability goes to his ability to interview or to even evaluate interviews. That's not what happened here. And the state has argued today that there was some engagement with the literature. Actually, the trial court said that the lack of engagement with the literature wasn't a problem because the relevant method was simply the interviews. This court in Martin didn't actually explore reliability because that issue was not well preserved, and this court expressed frustration that the issue was not well argued. Even then, this court said there are powerful reasons to not allow this type of testimony. We did not abandon the reliability argument. If you read the whole argument from trial counsel all the way to page 686, he's continually challenging the reliability and unhelpfulness, but to the degree that this court disagrees and thinks that he did abandon it, the frequency opinions by this witness are inextricable from the rest of his opinions. It's our argument that the text of 702B3 does not, that was in effect at the time of trial and which was argued by trial counsel, did not allow for blind testimony. But to the degree that this court disagrees, this particular witness's expertise was in interviews, and so if he were to come in and give some blind testimony about a good or bad, what makes a good or bad interview, that might be closer to being reliably applied to the facts of this case. Also, the state has argued today that comments like rare or common are not statistical, they're just some kind of shorthand. They are unfortunately shorthand for comments on probability, and the reason that that is so harmful here, especially with regard to the rarity of false allegations, is that reality doesn't conform to statistical probability. But the opinion that a phenomenon is real, or excuse me, rare or common, that particular opinion can be very misleading when what is reality is not, in fact, rare or common. For example, if you're outside and you see a funnel cloud, the fact that tornadoes are rare in Utah is not only not helpful to you, but it is harmful and misleading when you as a fact finder are trying to determine whether to get to safety. So those type of opinions are, they're not only unfounded, but they're also highly prejudicial. They're substantially more prejudicial than probative, and so we are asking this court to reverse and remand. Thank you.
Thank you to both counsel. We very much appreciate the arguments and the briefing in this matter. We'll take it under advisement.